a truly distinguished scholar and practitioner whose contributions have shaped the fields of international and European law, environmental regulation, and legal education. Professor Dr. Nicholas has an illustrious career that blends academic rigor, editorial excellence, and international consultancy. With deep expertise in international law, particularly environmental law, European Union law, comparative law, and educational program development, Professor Dr. Nicholas has become a cornerstone in the advancement of legal thought and practice. He is also an influential editorial board member for several leading journals, including the European Journal of Risk Regulation, the Journal for European Environmental and Planning Law. Beyond his scholarly contributions, Professor Dr. Nicholas has shaped the future of legal education by mentoring PhD and LLM students, civil servants, judges, and attorneys worldwide. His ability to bridge theory and practice has not only educated but inspired a new generation of legal minds to address the pressing challenges of our times. Today, we have the rare privilege to hear from a luminary whose work continues to influence policy, education, and law across continents. Please join me in giving a warm welcome to Professor Dr. Nicholas D. Sadler, Jean Monnet, Chair of European Union Law at St. Louis University, Belgium, a visionary thinker, global educator, and pioneer in his field.
Welcome, sir. Sir, over to you.
Yes, hello. Good morning. Can you listen to me? Can you hear me?
Yes, sir.
Yes, sir.
Does it work?
Yes, sir.
Yes, sir.
Yes. I'm very honored to hold a speech this morning. It's quite a change, but I'm staying in a hotel in Madrid, which is not my hometown, and so I have to leave the hotel in about 1 hour. So it's better that I intervene now. I imagine it might be a bit more difficult to hold a speech from a taxi in a traffic jam in Madrid this morning. So it's about 10 o'clock, 10 a.m. here. So I will follow the slides. Next slide, please.
Yeah.
And I will differentiate the investor-state dispute settlement among the different member states. So it will be the case of a Dutch companies investing in Slovakia or Swedish company investing in Romania. And there, the case law of the Court of Justice has been quite strict regarding investment dispute settlement mechanism that won't comply with EU law. So I will explain that first. And secondly, I shall place the focus on the manner in which the European Union, a union of 27 member states, envisions the settlements of disputes between an EU investors in Singapore or vice versa, Singapore investors in Europe. A number of treaties have been concluded on the matter. The two issues are quite complex on the account that the EU is not akin to a state or to a federation. It's an autonomous legal encompassing 27 member states, and it's not yet similar to a state or federal state or confederation of states. So I shall emphasize this. Next, please.
Next.
So I begin with the disputes that took place mostly between Western investors from Germany, from the Netherlands, that have been investing in Eastern countries that since 2004, 2007 have become member states of the EU. Next slide, please.
Next.
And that has been raising two issues. First, that the EU legal order is extremely developed. It's a body of treaties as well as a huge body of legislations encompassing internal market rules, common trade policy rules, as well as consumer or different type of agricultural rules. And I will highlight the conflicts that took place between the traditional arbitration, ISDS, and the EU legal order. Next slide, please. So the member states have been concluding, mostly Western states, agreements with former communist states such as Poland, Latvia, Estonia, um, Romania, Bulgaria, Slovakia, Czechia, in order to protect their banks or the manufacturing companies investing in these former communist regimes. So this international agreement have been concluded in accordance with international law. However, since 2004-2007, the host countries, the countries hosting the investments, have become a member of the European Union. So they are placed upon equal footing with the Western nations. And the Court of Justice ruled that this bilateral agreement on investment cannot affect the allocation of powers within the EU and consequently the autonomy of the EU legal order. The EU legal order is prevailing over the national law. And the autonomy of the EU legal order is justified by the essential features of the EU and its law, relating in particular to the constitutional structure of the EU and the very nature of that law. And that law is reckoning upon a structured network of principles and rules, and it's pursuing a number of common values, among which the rule of law, democracy, human rights, human dignity. So, although the EU is not akin to a state, the Court of Justice of the European Union considered that it has a constitutional structure. It's close to a constitutions, in spite of the fact that it won't be similar to the German legal order. Next slide, please. So this legal order is based upon the principle of mutual trust between the member states, between the domestic courts of the member state, as well as the principle of sincere cooperation. So the domestic courts in Romania, in Poland, in Germany have to cooperate with the Court of Justice of the European Union in bringing questions, in begging questions to the Court of Justice whenever an issue of interpretation regarding EU law is contemplating before the court. And there is a need to ensure a uniform and effective interpretation of EU law by one single court, that's the Court of Justice of the European Union based in Luxembourg. Next slide, please. And that uniform interpretation of EU law will ensure the consistency of the legal order, its autonomy, as well as it will enhance the powerful nature of that law that prevails over the 27 member states' legal order. So one understands that the court systems is quite centralized thanks to the preliminary ruling procedures, allowing every domestic court to beg questions regarding the interpretation of thousands of regulations, directives, treaties that pertain to that EU legal order. And that systems enhance a uniform interpretation of EU law. Without such a system, the EU legal order will be seriously weakened. Next slide, please. So questions have been raised in a conflict between an investor, a Dutch investor in Slovakia and the Slovakian state. And this conflict, this dispute has been dealt with by different German courts, and finally questions were referred to the Court of Justice of the EU. And two main questions were addressed. Was the investment tribunal Slovakia and the Netherlands likely to interpret and to apply EU law, and so that could undermine the unity of EU law. And the second question, were these investment tribunals created by the bilateral treaty regarded as a court or tribunal of a member state? Next slide, please. So the answer of to the first question was clear. These arbitral tribunals ruling, adjudicating disputes regarding free movement of capitals were likely to interpret or indeed to apply EU law, in particular these fundamental economic freedoms upon which the EU legal order is based, and that includes the freedom of establishment, a company in another member state, and the free movement of capitals. So arbitrators were likely to interpret as well as to apply EU law. And the question then, the second question was, is that correct with the EU system to allow arbitrators to act as domestic courts and to interpret EU law and even to apply it? Next slide, please. The answer to the second question is that these arbitrators were not akin to magistrates or to judges. These arbitral tribunals created by these bilateral treaties could not be compared with jurisdictions or domestic courts at national level. So these tribunals were not part of the judicial system of the member state. As a consequence, these tribunals could not cooperate with the Court of Justice of the European Union, asking the Court of Justice questions regarding the interpretation of the EU law. Next slide, please. So this judgment has been condemning the numerous provisions created by these bilateral treaties on investment law that were creating specific arbitral tribunal. Next slide, please. Yeah. Would it be possible to put the next slide, please? Yes, so that the court reached a conclusion that these arbitral tribunals adjudicating dispute between investors and member states were likely to undermine the full effectiveness of EU law. So as a result, it meant that only domestic courts in the European Union can adjudicate a case disputes between a German bank or an Austrian bank investing in Romania, and there is no room whatsoever for private arbitration, even if that private arbitration is provided for by bilateral treaties. So these judgments has been confirmed by four other judgments, and this is very consistent case law. Could you put the other slides, please? In the other slides, I gave the reference to the other judgments. You can move on 3 slides, please. So this is PH Holding, Comstroy, and Commission versus European Food, Swedish companies. And we can then move to the second part of my speech. So that's the references of these judgments condemning the practice of these investment dispute settlement bodies. Next slide, please. Next slide, please. Next slide, please. And then I come to these issues of the manner in which the European Union envisions to regulate in bilateral treaties or in multilateral treaties the investor state disputes. Next slide, please. And I want us to distinguish between two main categories of treaties. On the one hand, the association agreements that are quite common, and on the other hand, the free trade agreements, in particular, new generations of bilateral free trade agreements concluded by the EU with non-EU member states in order to enhance, to improve their economic relationship. Next slide, please. So the associations agreements are very specific to the EU legal order. It's a treaty that's concluded between the European Union in its own right, as well as its 27 member states. So there's considered as to be mixed agreement because they involve also the member states. And these treaties are concluded with a non-EU country or a bloc of countries such as Mercosur, with a view to establishing close economic as well as political cooperation. Accordingly, these association agreements governs a number of issues ranging from policy, trade, social, culture, as well as security. Several associations agreements have been concluded lately with Chile, Mexico, and um, we are working on the conclusion, on the signature of an agreement between the EU and Mercosur. Usually, these associations agreements do not provide specific provisions regulating the disputes between investors and the state parties to these agreements. Next slide, please. Besides, the EU is intent upon concluding bilateral treaties, and it has been concluded in the past, recently, a number of treaties with South Korea, Canada, Japan, Singapore, Vietnam, Colombia, Peru, Ecuador. And these agreements are replacing the existing 1,000 member states bilateral trade or investment treaties concluded with third states. So, in other words, the EU is prevailing over the bilateral actions of the member states. So it means that Germany has been concluding investment in trade treaties with a number of states. Whenever the EU intervenes, the German treaties have to disappear. These free trade agreements treaties are rather complex. They include, encapsulate many chapters ranging from the protection of intellectual property to sustainable development. In particular, each of these treaties contain a chapter on trade and sustainability referring to existing industrial law, such as industrial labor law or environmental multilateral treaties. Most of the chapters regarding public procurement, phytosanitary measures are actually WTO plus obligations, or they provide for greater investment protections. Next slide, please. So actually, the EU is negotiating with the Indian authorities FTA, trade treaties, and the EU has been launching, besides separate negotiations for the conclusion of an investment protection agreement, as well as an agreement on geographical indication with EU countries. So these treaties are still subject to negotiations. One can find the list of meetings and the minutes of the meetings on the website of the DG Trade of the European Commission in Brussels. So you can have full access to the minutes of these meetings showing the evolutions of the negotiations. So the aim is to achieve the conclusions of a proposal of treaties that first will have to be signed, and secondly, on the EU side, they will have to be concluded by the Council of Ministers, a council of 27 ministers, as well as to be approved by the European Parliament. Next slide, please. Um, there is negotiation regarding an investment protection treaty that will encapsulate the traditional provisions such as national treatment, most favored nation treatment, protection against expropriations without compensations, unfair treatment of investments, right to regulate, and so on and so forth. Next slide, please.
Next.
So in particular, this proposal is not is quite similar to other proposals that have been negotiated with Vietnam and Singapore. So it's aiming mostly at improving investment protection, and on the other hand, settle the potential dispute between investors and the parties. Next slide, please. In particular, the European Commission is trying to strike an appropriate balance, equilibrium between the competing private investors' interest and the public interest. So, for instance, this is the proposal made by the European Commission regarding regulatory measures. The parties affirm their right to regulate with a view to achieving legitimate policy objectives that do encompass the protection of human health, consumers, environment, including climate changes. And so the protections, the investors' protection agreements should not undermine the right of the 27 member states of the EU on the one hand, or of India on the other hand, to regulate in order to achieve legitimate policy objectives. So this is one of the illustrations of the ways in which the EU is trying to promote its values. So what matters when it comes to investment disputes, settlements, is that one has to be aware of the strong public opposition in Germany and in Belgium, as well as in France, regarding the traditional ISDS, and that led even to a few years ago to a significant case regarding the signature of the CETA treaties, the EU-Canada Treaty. And the narrative of the EU is that an investment court that will be encapsulated in different bilateral treaties, such as EU-Vietnam, EU-Singapore, or EU-Canada, will evolve into a sui generis permanent multilateral industrial court. So the idea is to shift from multilateralism, because it's impossible to convince China or the USA regarding the opportunity of such a court, to bilateralism, and to encapsulate such a court as a bilateral court in the different treaties, with a view in the long run to create a permanent intramural court. Next slide, please.
Next.
So um, the, the treaty, the proposal of the investment agreement with India provides for, on the one hand, a permanent first instance investment tribunal, that's Article 3.9, that will um, uh, and the adjudicators will be competent, independent, impartial, so adjudicators instead of arbitrators, no conflict of interest, and they will be appointed not to adjudicate one single case as the traditional ISDS, but they will be appointed for a 6 years terms in order to adjudicate different cases, and in so doing, to enhance the consistency of the case law. Besides, the chapter of the proposed agreement provides for the creation of a permanent appeal tribunal, and this appeal tribunal do not exist in the field of ISDS, and that must be done in order to ensure the predictability, the consistency, and the correctness of the awards that will be granted by the permanent first instance investment tribunals. When one zooms in to the chapter, and that chapter is not really original, it's quite similar to the other chapters that have already been concluded with Canada, Singapore, and Vietnam. One can reach a conclusion that we're quite close to a traditional judicial domestic system where there is a court of first of instance, and then the possibility for the appellant or the claimant or the defendant to appeal before a court, and these courts, these domestic courts, according to the rule of law, are deemed to be impartial as well as to be independent. So, in looking at the chapter, one's really can take the view that the EU is trying to depart from the traditional investment dispute settlement mechanism that has been quite criticized by the public in the Western countries of the EU, and to move into something completely original. Next slide, please. So, if I compare the two parts of my expose, with respect to the disputes between a German bank or an Austrian bank and the Polish authorities, these disputes have to be adjudicated by the national courts, and these courts must cooperate with the Court of Justice. So, whenever there is a questions regarding the scope of the freedom of establishment or the freedom of transferring the capitals, these domestic courts must refer the questions to the Court of Justice, and the Court of Justice must enhance the uniformity of EU law because it's the only source of interpretation. Whereas, with respect to a possible treaties, a possible agreement on investment, on trade with India, this is the traditional principle of reciprocity between the EU and the non-EU states. So it means that in case the treaties on the protection of investors will be concluded between the India and the EU, it will entail the protection of Indian banks or Indian hedge funds within the EU, within the 27 member states, as well as the protection of Spanish banks such as Santander in India. Next slide, please. So here I compare again that EU law is part of domestic law. So that's what I'm explaining every day to my students. That Belgian law is subject to EU law. So EU law is really part of the Belgian law. The Court of Justice of the EU has this exclusive jurisdiction to interpret EU law. And regarding the extra EU disputes within the scope of this bilateral approach the EU is promoting, we are falling outside the EU judicial systems, but there is a willingness to provide for a dispute a settlement mechanism that's much more independent, much more impartial, that's much more professional. This court being composed of long-term magistrates that are appointed for long-term periods and that have no vested interest in the case. So hopefully I've been trying to I succeed in highlighting the difference between the dispute that must be settled at EU level by the domestic court, but with the cooperation of the Court of Justice as a single authorities when it comes to interpretation, and a very original model that's promoted by the EU in the conclusions of trade and investment treaties with non-EU states such as India. Thank you very much indeed.
Thank you, sir.
Thank you,
Thank
sir.
you
Thank
so
you
much
so
for
much
your
for your
captivating
captivating
special
special
talk.
talk.
Now we
Now
shall
we shall
move to
move
our
to our
next
next
session.
session.
We will
We
hear
will hear
from
from
some of
some of
truly
truly
distinguished
distinguished
speakers.
speakers.
Professor
Professor
Dr.
Dr.
Shirina
Shirina
Waslu,
Waslu,
Professor of
Professor of
National Law
National Law
University,
University,
Juridical
Juridical
Science,
Science,
Kolkata.
Kolkata.
Before
Before
we
we
start
start
with
with
sir's
Sir's
presentation and
presentation and
speech,
speech,
I will
I will
request
request
my
my
colleagues to
colleagues to
brief
brief
about
about
the
the
answer.
answer can continue.
Professor Dr. Srinivasulu NS is working as a professor of law at National University of Juridical Sciences, Kolkata. He is a distinguished member of International Council of Jurists, London. He is a scientific member of Canadian Institute for International Law, Ontario, Canada. He is also associated with the World Commission for Human Rights, London. He is a recognized author and has got to his credit over 110 research publications, including 7 books, 3 monograms, 9 edited volumes, 15 book chapters, and 75 research papers published in more than 35 varieties of journals and international publishers such as Oxford, London, UK, Penguin, Indiana, USA, and Butterworth's LexisNexis. He worked with Ministry of Justice, Ministry of Commerce, Ministry of Human Resource Development, Ministry of Transport, Government of India, and UGC for policy advice. He has also provided policy advice to Government of Karnataka, Government of West Bengal, Government of Assam, and Government of Goa on legal education, law, and policy issues. Today, we have the privilege of hearing from a scholar whose work bridges theoretical rigor with practical relevance. Professor Srinivasulu's dedication to justice, equity, and the advancement of law serves as a beacon for all who aspire to make a difference through the legal profession. Please join me in extending a warm welcome to an outstanding educator, a visionary scholar, and a tireless advocate for the rule of law, Professor Dr. Srinivasulu NS. Over to you, sir.
Thank you. The organizers have given me a special topic today to speak on the interplay between IPR and investment law with special reference to the space sector. I would have wished Professor Lokanath to be present because space is connected with his own subject, physics, electronics, space, and robotics. So it involves some amount of science as well. So probably the Honorable Vice Chancellor would have enjoyed the discourse, which is connected with his own discipline of physical science. Nevertheless, so investment law and IP law with a special reference to space sector. As far as space research is concerned, we have ISRO in India, Indian Space Research Organization, and which came into being in the 1960s. ISRO has been doing pioneering job as far as the promoting space research in India is concerned. Of course, not only for India, Indian Space Research Organization has been doing monumental job for a number of other countries whose research also involves our ISRO. Perhaps ISRO itself is having number of intellectual property rights. ISRO itself is promoting a number of investment platforms. That is how I can connect the investment law and intellectual property law in the space sector. Of course, since 1973, when ISRO got its first patent, till now, there are about 300 patents that ISRO has obtained till 2024, September 24. ISRO is having 82 copyrights and 13 trademarks till October 2024. As of November 2024, ISRO is having altogether 315 intellectual property rights, including, as I said, 300 patents, 82 copyrights, and 13 trademarks. So ISRO as an organization, as a public organization funded by Government of India, is having this many patents, copyrights, and trademarks. And these IPRs, whatever I mentioned, are not just from Indian patent or copyright offices. ISRO has obtained these patents, copyrights, and trademarks from at least 20 countries, including India. ISRO has obtained patents and copyrights from USA, Russia, Singapore, Philippines, Netherlands, and such other countries. As I mentioned, 20 odd countries ISRO is having its IPRs. And ISRO is having the intellectual property rights in these 20 countries where it has got some investment opportunities. ISRO has been promoting the cause of intellectual property rights. At the same time, it is promoting investments also. We have investment treaties with these many countries as well, for the reason which ISRO is pioneering in terms of not only entertaining these countries to use our ISRO space station, ISRO is not only letting these countries to use our satellite centers or satellite launching pad at Sriharikota, and as well ISRO is obtaining patents, copyrights, and trademarks as well from these countries. Most of the patents with reference to the ISRO's research, this ISRO's investment portfolio, is perhaps revolving around development of satellites, the manufacturing of satellites. On these elements, ISRO is having number of patents. It goes without saying that in the past 10 years, ISRO is not alone manufacturing satellites. It has involved some private parties also to help it out or to have association for the purpose of manufacturing of satellites. Especially the startups in Hyderabad are helping out or are associated with ISRO for the purpose of manufacturing of satellites and
Stop with the recording in that case. For time being. Pause.
Recording stopped.
Just wait. He will fix it. Might be there is a network problem. Okay, now.
Recording in progress.
Sir, we are not able to hear you. Sir, can you check with your network?
hello.
Right.
Right.
Am I audible?
Yes, sir.
Yes, sir, you are audible, please.
Yeah.
Yes, sir.
Yes, sir, please.
Please
Please
proceed.
proceed.
Yeah, there is some technical glitch. I'm not getting your.
Okay, no
Okay, no
problem.
problem.
Please continue, please.
No, that's it. Network. Yeah, no.
Recording stopped.
When he start again, wait. Okay, we go to the next. Let me ask him. Just a minute. You stop your recording. Okay. Let me call him. If he's ready. Just a minute. Till he comes. Just wait. Allow him. Sir, yes. Can you join us now? Sir, can you join us now? I'll call you. Can you? Yes. Sir, can you join us now? Okay, right. We will call you. Please join us. We put signal slow at the end. Right. You can allow me.
Recording in progress.
Right. Now
Now
it is our honor and privilege to welcome Professor
Antonio
Georgie
Giorgi
to
to
deliver
deliver
his
his
speech.
speech.
Please,
Please,
sir,
sir, over to you.
Before
Before
you
you give a
we
speech,
would
we would
like
like
to
to brief about you, sir.
Please, sir.
Please, sir.
It is a great privilege to introduce a distinguished academic and legal expert whose extensive contributions to the field of law and education have had a profound impact both in Brazil and internationally. His academic and professional career has been marked by leadership and innovation. At University of Fortaleza, Professor Dr. Antonio Giorgi leads the private law and the constitution research group and teaches didactics of legal education. As a member of the board of the Center for Legal Sciences, they are instrumental in shaping the next generation of legal professionals. Professor Dr. Antonio Giorgi has contributed to a wide array of groundbreaking research projects, including exploring private autonomy and religious freedom, investigating the methodology of teaching law, analyzing the interplay between private autonomy and constitutional, economic, and social orders as defined by the Federal Constitution of Brazil, examining corporate accountability for human rights violations. In addition to his research, Dr. Antonio Giorgi has been deeply involved in advancing legal education and practice, with notable contributions to projects on business law, international management, and existential rights, focusing on the protection of vulnerable populations. Today, we have the opportunity to hear from an expert whose work bridges the theoretical and practical dimensions of law with a commitment of fostering justice, equity, and innovation in the legal system. Please join me in extending a warm welcome to Professor Dr. Antonio Giorgi, a visionary educator, researcher, and advocate for constitutional and human rights. Over to you, sir.
Well, thank you. Well, are you listening? Are you listening to me?
Yes,
It's okay.
yes.
Okay. Well, thank you very much, Mr. Syed Kundrak and other authorities for the opportunity to join the select group of experts. It's an honor to be here today to discuss a little topic of utmost relevance in the current global scenario, the protection of intellectual property and investment within the BRICS framework, which comprise Brazil, Russia, India, China, and South Africa. This group of emerging nations plays a crucial role in the world economy, and effective IP protection is essential to foster innovation and sustainable economic growth. Well, just 10 years ago, we were appointed our countries as the worst this topic. So we are just now preparing ourselves, our countries, to be best in this topic. So just a little words about Brazil perspective. Brazil, as one of the BRICS members, is at a critical crossroads regarding IP protection. With diversified economy that spans from agribusiness to information technology, Brazil is fertile ground of innovation. However, for the innovation to thrive, it's imperative that IP rights are robustly and effectively protected. We are trying to do our due in this topic in Brazil. Recent years, Brazil has made significant efforts to modernize its IP structures. The National Institute of Industrial Property has implemented the digitalization of processes, an initiative that has already reduced the waiting time for patent and trademark registration by about 30%. This advancement is crucial as an efficient IP system not only encourages inventors and creators, but also attracts foreign investments which are vital for economic development. So, some challenge for our countries in the BRICS framework. One of the main challenges faced by BRICS countries is the harmonization of IP laws. Each country has its own set of regulation and practice which can create barriers for companies operating in multiple jurisdictions. In Brazil, for instance, the patent registration process can be lengthy, taking an average of until maybe includes a lot of years includes to complete. This delay can discourage innovation investment in high-tech sectors. Moreover, the enforcement of IP laws varies significantly among BRICS countries. In Brazil, although we have a relatively robust judicial system, we still face challenges such as procedural delays and the need of greater specialization in IP matters. This can lead to inadequate protection of IP rights, negatively affecting investor confidence. So another significant challenge is combating piracy, and counterfeiting. In our country, it's very common. People who do piracy, which continue to be major issues in many great products is the market not only harms legitimate business but also poses risks to consumers and the economy as a whole. In Brazil, it's estimated that piracy causes annual loss of billions of dollars to the economy. So we can just talk about opportunities. Despite these challenges, there are numerous opportunities to enhance IP protection and attract investment within BRICS. One such opportunity is strengthening cooperation among members countries. Brazil has seen efforts to modernize the National Institute of Industrial Property, aiming to reduce the backlog and make the process more efficient. Though joint initiatives such as sharing best practice and developing capacity building projects, BRICS countries can improve their IP system and create a more favorable environment for innovation. Digitalization and technological advancement also we can continue to work together to strengthen IP protection and promote investment in our nations. Together, we can transform challenges into opportunities and build a more innovative and prosperous future for all. Thank you for all for your attention.
Milan. Thank you so
Thank you
much,
so much,
Professor
Professor
Antonio
Antonio
Giorgi,
Giorgi,
for your
for your
invaluable
invaluable
insight
insight
into the
into the
BRICS
BRICS
framework.
framework.
Now, we
Now,
are
we are
privileged to
privileged
hear
to have
from
from
our
our
esteemed
esteemed
speaker,
speaker,
Professor
Professor
Dr.
Dr.
Kenneth
Kenneth
Mutama,
Senior
Senior Faculty
Faculty
of
of
Law,
Law at
Nairobi Law
Nairobi Law
School.
School.
Before we
Before we
join
join
what
what
Sir's
Sir's
presentation,
presentation,
I would like
I
to
would like to
request
request
Ms.
Ms.
Sarah to
Sarah to
brief
brief
about Sir.
about Sir.
It is with great honor and enthusiasm that I introduce to you an esteemed scholar and practitioner whose profound contributions to academia, government, and civil society have left a lasting impact across Eastern and Southern Africa. Today, we are privileged to hear from Dr. Kenneth Wayne Mutuma, a senior lecturer at the University of Nairobi School of Law. Dr. Mutuma has over a decade of teaching experience where he has shared his expertise in international humanitarian law and related subjects. His dedication to advancing the understanding and application of these critical areas of law is evident in his collaborative work with academia, governmental institutions, and civil society organizations. Before his tenure in academia, Dr. Mutuma played a pivotal role as a legal officer at the United Nations High Commissioner for Refugees. There, he was instrumental in implementing policies concerning refugees across the Great Lakes and Horn of Africa regions. His commitment to promoting humanitarian principles further extended to his role as a legal officer with the International Committee of the Red Cross in Nairobi and Pretoria, where he supported the application of international law in conflict situations. Dr. Mutuma's influence extends beyond his legal practice. He has worked with the Nelson Mandela Foundation to develop the capacities of governmental bodies and civil society organizations in conflict resolution and ethical leadership. These experiences underscore his dedication to fostering peace, justice, and ethical governance in Africa and beyond. Academically, Dr. Mutuma's credentials are equally impressive. He holds a PhD focusing on the challenges of outsourcing war to private entities, a subject of critical importance in today's global landscape. Today, we have the distinct honor of learning from Dr. Mutuma as he shares his insights. His unique blend of academic rigor, practical expertise, and a deep
Recording stopped.
to humanitarian principles
Recording in
promises to
progress.
inspire and challenge us all. Please join me in welcoming Dr. Kenneth Wayne Mutuma, a visionary leader, scholar, and advocate for justice and humanity. Over to you, sir.
Yes,
Yes,
Dr.
Dr. Kenneth.
Next
Next
Dr.
down, Dr.
Kenneth.
Kenneth.
Yeah,
That.
Hello, am I audible?
Yes, sir.
Yes, sir, you are audible.
Please join.
Please join us.
Oh dear, I don't.
Yes.
Yes,
We would like
we
to
would
see
like
you,
to
sir.
see you, sir.
Could you come
Could
to
you
the
come to
camera?
the camera?
Uh, uh, Colleagues, are you able to hear me?
Yes,
Yes, we are
able
able
to
to
hear
hear
you,
you,
sir.
sir.
All right.
Yes.
I
For some,
confirm I hear
Yes,
you.
sir.
Yes,
Yes,
sir.
sir.
Yes, sir.
okay, I can hardly hear you, but if you can hear me, then I will
Yes, start,
Yes,
sir.
start, sir.
proceed.
Yes, please
Yes, please
proceed.
proceed.
Please
Please
proceed.
proceed.
Okay, I think let me proceed. I'm having a bit of difficulty, but I'll just trust you can hear me. I want to thank very much the organizers. Um, as always, I think the university and this kind of inter um, international collaboration, including several universities and several experts in the field, and specifically continental collaboration has been very useful for us at the University of Nairobi. I was only going to make a very few remarks. I'm very honored always to be here, and I'm very honored to also have listened to a number of the speakers, including the chief guest that spoke on this subject. I am predominantly an arbitrator and an adjudicator, and my remarks
Is in the car.
around cross-border investments, VITs, the idea of investment growth, specifically between Eastern Africa and India, is premised on
I don't know his number.
arbitration as a dispute resolution mechanism. I won't go into the context, historical context of arbitration. I think essentially those that know something about the subject will know that it is the world of arbitration stems from intercontinental trade, mercantile trade that ran across the sea, and some of the customs and usages that began to be adopted because of that. Of course, a lot of the discussions center on Europe, but it's very important to clarify that even within the South, and specifically between India and East Africa, there has been a history of economic ties, trade, trans Indian Ocean trade, and that there were informal mechanisms that undergirded or underpinned that trade. So I know for most arbitration practitioners, the discussion center very much on the transatlantic notion of what is happening between Europe predominantly and the Americas, but we do need to be aware, and we are swiftly awakening up to the historical trade relations that existed between many of the Southern Hemisphere countries and India and East Africa, I think, are the ones that stand out in more recent times as a focus of the discussion. They are, again, in the context of this um, conversation, regional developments, more modern regional developments on the continent that are taking uh, or at least fostering the level of trade relations between India and Eastern Africa at a very high level. One of them, of course, is the African Continental Free Trade Area, popularly known as the CFTA, and the kind of alignments that are happening with India based on global investments and how Africa as a bloc is seeking then to reinvent the idea of bilateral trade. So moving it from individual states to the continent negotiating as a bloc. Of course, there are challenges, even in the economic context, mainly stemming out of law. The regulatory framework within the continent can be quite diverse, much of it owing to the colonial history and the different jurisdictional patterns that flow out of that common law system, the civil law system, and harmonizing laws across those different divides. But there are other challenges, certainly when you think about the, the different political terrains that Africa cuts across and the different socio-cultural um, uh, shades that you will find also on the continent. So while Africa can be said to be homogeneous in certain respects, it still has those diversity parameters across. As far what this means for arbitration in this particular world is that there is a lot of focus that is now being dedicated to harmonizing legal frameworks. Originally, of course, that harmonization was happening at a global level and stemming from what we had earlier, the Exit Convention, um, and other aspects such as the New York Convention, because the idea behind bilateral trade was the comfort of the investor um, vis-a-vis the power of the state within its jurisdiction. That, of course, has opened up a new arena where it's felt that the is too much comfort and security that's been given to the investor, and in many countries which are experiencing a resurgence in their constitutional dispensation, that has been done at the expense of the norms, values of the populace. For example, in the context of environment, the context of public participation, and many of the projects that are investor state oriented. Um, uh, the other development, of course, has been the multiplication of arbitral institutions across the continent. Here in Kenya, we have the Nairobi Center of International Arbitration. We also have within our neighborhood other centers such as the Kigali Center, the Cairo Center, and so forth. All of these emphasizing the importance of private dispute resolution mechanisms that take matters out of the hands of the formal judicial system, the courts, and for good reason. I think that many of the benefits of arbitration have been sort of scoured around, and I won't go into them. Just suffice it to say that a lot of it relates to risk mitigation, and that the public judicial system, as fractured as it is across different countries, presents formidable risks to an investor. And these arbitral centers and dispute resolution mechanisms that point to arbitration in the PITs are really about mitigating risk and promoting investor confidence. So there are challenges. That said, um, some of the challenges, of course, in the world of Indian East Africa relations has been around ownership and capacity. The debate around how suitable arbitrators are picked, where those arbitrators are from, and their neutrality in the sense of that a lot of these projects do have a national ethos in them. So there are contentions around the arbitrator selection. There is a very huge discussion around the relationship between those platforms and national courts. And again, that points at the need for extraordinary capacity development. The debate has changed from what it used to be earlier, where national courts were jealous over their jurisdiction and they didn't know much about arbitration. The debate today is really around the extent that public law is invading into private law space. There are a lot of aspects that are contractual within the overall framework of investment that are now coming under the scrutiny of public policy, public interest, such as public participation. I had mentioned the environment and social governance, many constitutions placing a heavy emphasis around human rights as a core, and how that then juxtaposed in the private law domain presents opportunities for interventionism as by the courts, essentially. So we've seen that, for example, in our part of the world with the employment and labor relations court, and how a lot of aspects that are purely contractual are now being interpreted in the language of human rights and what that actually means. That said, the references that we had made to the consolidation of the BIT perspective under the CFTA, the African Continental Free Trade Area, is a good indication on the future prospects of BITs as far as the relationship between these two significant economic zones is concerned. I think the philosophy of integration through BITs through the continental framework is something that we can anticipate to influence the investment climate in the future. Having said that, I think there are many various other aspects that lend an optimistic picture to the future. Actually, chief amongst them, when you're speaking about the East African region and India, is of course generally the common heritage of their jurisdiction systems, and both of them are very strong common law jurisdictions. And in fact, India, being the older economy in this area, does provide very, very valuable precedents that are of major or great persuasion in the East African courts. Please allow me to stop there for the moment. Unfortunately, I wasn't able to put on my video because of a few distractions on this side. But allow me to hand over to the organizers. I hope I have been audible, and I'd like to say a very, very big thank you to the University of Mysore for the wonderful work that you're doing in enhancing this collaboration. I know there are one or two other projects that are ahead of us in this coming month on a different thematic area, and we truly applaud the university for fostering this wonderful partnership. Thank you very much. I hand over back to the organizers. Thank you.
Thank you so much, Dr. Kenneth, for your thought-provoking speech. We are
We are
honored to
honored to
close
close
our
our
webinar
webinar with the talk by Professor Shirina Waslu.
Yeah, I'm back
Yes.
because of technical glitches. I'm
Yes,
not
sir.
putting my video on.
No problem.
No problem, sir.
Please,
Please
proceed.
proceed.
I'll continue.
Yes,
Yes,
proceed.
please.
Thank you so much for having me today for the program. And my special topic is with respect to, my topic is with special respect to space sector, space industry. How exactly space industry is poised to bring these two conflicting fields of law, investment law and intellectual property law. That is focal point of my presentation today. It all began with 1996 Supreme Court judgment. The amalgamation of investment sector and intellectual property sector started to make the real happening. All those people who are fans of cricket must be having, especially Professor Suresh Benjamin and Professor Ramesh must be having a fatigue remembrance that during 90s, most of the cricket matches used to be sponsored by either Pepsi Cola or Coca-Cola. So it used to be always a fight between Pepsi Coke and Coca-Cola. During 92 World Cup, 96 World Cup, and as well 99. A very remarkable thing happened during 1996 World Cup, wherein the Cricket Board of India, Board of Cricket Control in India, BCCI, filed a case against Doordarshan. Because till 96, it was only the Doordarshan which used to broadcast or provide live pictures of all the cricket matches. So BCCI wanted to interfere with that, saying that government only cannot monopolize spectrums. Government cannot be the only monopoly entity on broadcasting, telecasting of cricket matches or any sports events for that matter. So in a remarkable decision in 96, Supreme Court of India opened this spectrum, broadcasting, convergence, media for the private players. And we all know that as far as media and telecommunications are concerned, it is Rupert Murdoch, the founder of BBC, British Broadcasting Corporation, right? Who happened to open the floodgates for this private broadcasters, private investments in the broadcasting and telecommunications sector. And of course, this broadcasting and telecommunications sector has got its raw material in the space industry. Because of the launch of satellites, space shuttles, you are able to have broadcasting and telecommunication rights. So in the 80s, Rupert Murdoch of BBC UK and 1996 Supreme Court of India decision to open up broadcasting and telecommunication sector for the private players laid foundation for the growth of not only space and telecommunication sectors, but as well for the coming together of investment law and intellectual property law. Aftermath of 96, you must be having some idea that especially from 2004 onwards, we have seen this spectrum auctioning, 2G spectrum, 3G spectrum. Of course, a lot of news we happened to hear about 2G spectrum. A big scandal took place and all during Manmohan I government and all that. So that is because that was the first time the telecommunication and broadcasting sector invited private parties to go for auctioning. And then, because we had no background, no proper rules and regulations at that point of time, it gave rise to that spectrum scandal and things like that. Now, recently we saw 5G spectrum, right? So this is a telecommunications and broadcasting industry, which is dependent on space sector. Because of the satellites that you are launching into space, artificial space, celestial bodies which are there present in the space orbiting around Earth and other celestial bodies, they are supplying the data to you. They are supplying the broadcasting data, remote sensing data, and stuff like that. And aftermath of 96 in India, especially, since we have opened up private parties also to take part, private parties started having rights in broadcasting and telecommunications. We can also see that aftermath of 96, it all started with Z Network, Sony Network, Sun TV Network, right? And now number of television networks started. Now we have number of FM channels also, right? All this is because of the fact that you opened up, floodgates for the spectrum auctions, like Professor Suresh mentioned beginning, 1991, you opened entire economy for the private players to participate. 96, you opened the space economy, space sector for private participation for promoting space economy as such, right? So such being the case, the growth of media, the growth of broadcasting and telecommunications channels, right? And more investment is going into that because every day a new broadcasting and television channel is coming up, and every week you are launching a new satellite into the space. As of 2024, there are 2,000 satellites which are operating in this space, which are belonging to USA. 500 satellites are there owned by China, and India is having 60 active and operating satellites in this space, right? US 2000, China 500, India 60. Now, there are 18 space active nations out of 220 nations that we have now, as per United Nations registry. Only 18 nations are space active. In the sense, only 18 nations are participating in a space exploration, or they have launched space shuttles, satellites, and all that. And only these 18 nations satellites are supplying all that telecommunication, broadcasting, whatever data information to the rest of the world. Right now, if US alone is having 2,000 satellites, count the other 18 space active nations, it would be around 10,000 space shuttles must be going around in the space. Right now, you imagine the Bangalore majestic, the bus stand from aerial view, how it looks like. Now, probably the similar way, if you look, from the above the galaxy, it will be Earth will be sounding like that. 10,000 satellites moving around the Earth, along with our own moon. right? So that's why I call these satellites are artificial celestial bodies, whereas your moon, sun, and all natural celestial bodies, right? So the growth of the space sector, space industry, number of satellites that you are launching for broadcasting telecommunications purpose in particular, and now in the past a decade, if you can see, every activity is having some or the other connection with the satellites. Films are having satellite rights, sports events are having satellite rights, reality shows are having satellite rights. All our day-to-day communications, ranging from your Twitter, Facebook, X, till your WhatsApp, are connected with the satellite. Our travel is connected with satellite GPRS. Our banking communications, Google Pay, Paytm, whatever, through satellite. So everything from dawn to dusk, we are now dependent on satellites, satellite communications, satellite signals. And that's the reason why now we are talking about investment in space sector. Private players are launching satellites. Private players are putting investment in the satellite business. Very recently, just in the last month, Infosys happened to invest in one upcoming startup company in the space sector. Of course, India has got more than 100 startup companies which are investing in or working in the space sector, maybe space shuttle manufacturing or creating a separate special software for satellites working, remote sensing, broadcasting, receiving signal, maintaining it, stuff like that. Electronic people would understand it in a better way, right? For different purposes, ISRO, the Indian Space Research Organization, right, now it is outsourcing. ISRO itself in the past 10 years started 3 new independent agencies: National Space Agency and National Space Activities Promotion Board and stuff like that. It is all happening because you are going for space commercialization, space exploration. You are providing for private and public participation in space sector. All that is becoming a reality because you are inviting direct investment. 100% foreign direct investment is allowed now in space sector. 100% private participation is allowed now in space sector. I was mentioning, that the ISRO itself is having more than 300 IPRs on, with respect to space research and space exploration. Now it is possible that even private players who are operating their own space shuttles, who are having their own space stations, can also go about having it, right? So what I'm trying to say is more and more amount of usage of your internet, data, communications, broadcasting, television related rights is giving rise to more and more investment in space sector. More and more investment in space sector is giving rise to more and more innovations, more and more creativity. That's the reason why, starting from 1973, when ISRO, on behalf of Government of India, obtained its first patent, till 2013, 10 years back, India was having hardly 50 IPRs. Now, in the past 10 years, from 50, it has gone up to 380. So, in the past 10 years, why it happened? Because you opened up, right? You have opened up the space sector for private participation. You are allowing private, not only participation of private people and investment. And now this space research, space exploration is not just confined to telecommunications alone, right? It has got its role to play in most of the sector, including biotechnology. I will give an example. The way the cell division takes place in the inside the body of mother womb, the way the life takes its evolution inside the body of womb of mother. Similar kind of situation, we call it as zero gravity. Outside this earthly orbit, what we call as space, no air, right? Zero gravity. In that gravitational level, in the space shuttles, for the purpose of biotechnology, now biotechnology industry is looking for sending satellites there and sending some tissues over there into zero gravity area, and there the atmosphere will be like what you will have in the mother womb, and there they are going for cell division, right? There they are going for tissue culture in the zero gravitational power, right, which suits the atmosphere inside the womb of the mother. And having got it developed over there, they would like to bring it back, right? you can compare it with in vitro fertilization as well, right? Zero gravity situation, they would like to use an Encash. Of course, for that purpose you need to go about structuring, manufacturing special space satellites, agree, but still there is a way to go, right? And your artificial intelligence is also there present. So what I'm trying to say is not only the life of human beings, the entire globe is now trying to use what is happening in the space sector or space industry. That's the reason why government of India happened to bring about a new space policy of government of India in 2023, wherein it has categorically mentioned that space research, space sector is no more the monopoly of government of India. Having learned lessons from 1996 Supreme Court decision in that classic case of BCCA versus Doordarshan, which opened gates for private participation in entire entire spectrum, including space, telecommunications, broadcasting, and space research. Now, 2023 space policy not only encourages private parties, but it is saying very categorically that private investment to the extent of 100% in certain identified sectors is allowed. Very recently, just in the last week, Nirmala Sitharaman, our finance minister, made an announcement that government of India has earmarked 1,000 crores for venture capitalists who are involved in space research. They will give subsidy to startups, new companies, SMEs who would like to venture into space research. Why all these things are happening? Because more and more innovations are required in the space sector, more and more creative work is required in the space sector, and for that government cannot alone take care of it. That's the reason why they're entertaining private people, right? As I mentioned, ranging from your travel, your telecommunications, your biotechnology related medical field, mining, through remote sensing, in which area what type of mines are there, right? Earlier we used to follow certain rituals to find out what is there inside the earth. Now satellites from away from you, they can identify what is below you, right? It can give you global view, at the same time it can give you local view and inside view as well. So remote sensing, the satellites can sense what is there beneath earth, which kind of mines are there, coal mines, gold mines, water resources, all that is happening through satellite remote sensing. We call it as remote sensing data. And earthly environment, geospatial data, right? Geography, you must have heard about. Earth science, you must have heard about. Inside the earth, geology. Above the earth, geography, geospatial data, right? Geology and mining, we must have heard about. There you have remote sensing data. All this data is actually generated by your space shuttles. So your mining industry is now dependent on space shuttles, right? As I mentioned, your banking transactions, your banking and financial industry is depending upon your space shuttles, weather forecasting, fisheries, agriculture, right? When it will rain, when it will not rain, down the line 6 months, Kharif season, what will be the rainfall? In Rabi, what could be the rainfall? All that you are able to not predict, but forecast. There is a lot of difference between prediction and forecast, right? Forecast is happening through technical means, through your satellites. Prediction may be the job of astrology. Even that astrology is also becoming a very serious kind of business or field of science because of the operation of these artificial celestial bodies, what you call as space shuttles. So these many developments that are taking place in the space sector are giving rise to number of private players taking a part in it. That is drawing huge amount of investment and huge amount of generation of jobs also. Let me tell you that the space industry in India as of now already has given 5 lakh jobs. There are more than 100 space related companies in India. There are about 4,000 IPRs already on the Indian space research. 1,000 crores government of India has earmarked for to give subsidy. The contribution of Indian space sector in terms of world space, global space research and exploration is 2% as of 2024, and government of India is planning to make it to 10% by the end of 2030. And of course, by 2035, government of India is planning for Bharatiya Antariksh Mission, Indian space mission. You must have heard about USA, Russia. They're having their own space station, permanent space station in the space. Like that, government of India is planning for it because they also want to have something very certain in the space which will continuously 24/7 across the year will be giving you regular information like what USA and Russia is having, right? Like unlike other 18 space active nations, US and Russia are having very prominent base as far as space research is concerned because of the fact that they are technically very sound and they have a permanent space station over there. And more than all the other 16 space active nations, these two nations are having their dominance over there, and that's the reason why their investments are also looming large in terms of not only telecommunications, broadcasting, and entertainment industry, as I mentioned, ranging from banking, agriculture, fisheries, mining, all these sectors are actually now dependent on space shuttles and getting accurate results. Depending upon the space shuttle's activity, depending upon the information data that it generates and supplies to you, you will go about making investments. If in the coming rainy season, if the rains are going to be average, you will not invest much in the agrarian companies. If in the coming month, the weather condition will not be that docile and reasonable, you will not invest, especially in the sea coast, you will not invest much in the fisheries sector. So like that, in advance information, whatever you can get that you are obtaining from space shuttles, depending upon that, your investment is taking place. And now big private parties, big or giant companies, they're having their own satellites, starting from Rupert Murdoch, first individual to have private satellite. Of course, first entity, BBC, to have their own satellites. Like that, now every big company are having their own satellites and they are depending upon the signals, information, data provided by themselves. Especially in the Indian scenario, it all started aftermath of your 2G spectrum auctions after 2004. Aftermath of which you happen to allow private participation. So what I'm trying to say is, in the past 3 decades, that investments, private participation and investment in the space sector is growing. Number one. Number two, ISRO alone, without private participation, without private investment, could gather up to almost 400 IPRs, 300 patents, 80 odd copyrights, and rest of the number is trademarks. And if a private parties also come in, and if you allow private parties also to have file their IPRs and all, now as of now only ISRO is filing IPRs. Though private parties are allowed to invest money and all, it will be a joint collaboration. Only ISRO is allowed, because a lot of security issues will be there, because satellites they can capture where the person is. No, it will have some defense and security related issues. That's why you are not letting these private parties to have IPRs, even if you are allowing them to participate in space research and development. Because of defense and security reasons, you are not letting them to obtain or file for IPR. But nevertheless, you are giving them like you give second author or second inventor kind of stuff without giving them control. You are your financial benefits you are giving them, but no authorship or no complete control over the invention or whatever IPR that you are actually granting to. So at the outset, it appears to me that in the coming 10 years, whatever investments that we are having now, whatever startup companies which are there in the space sector now, about 100, that will not become double, but it will become manifold. The way the government of India is trying to promote space sector, in the coming 10 years, not only we will have Bharati Antariksha Mission, that is a permanent Indian space mission in the station, rather in the orbit, in the space whatever we have as a permanent artificial celestial body. We will have more than 1,000 companies participating in the space sector research in India. Slowly and gradually, like we are getting used to now artificial intelligence. Slowly and gradually, like we are getting used to biotechnology, right? Without saying this also, we are already depending on satellites only, morning to evening, down to dusk, right? It will become more apparent, more visible, and when down to dusk, when our life is dependent on something, right? It will have commercial ramifications as well. So down the line, 10 years, investment will be more in a space sector, and as a result of which IPRs will also grow, and the investment in the space sector would not only give rise to more and more number of IPRs, and more number of IPRs will have a cascading effect on the sectors. It will incentivize, it will reward those people who are investing and giving rise to the exploration of space for the purpose of mankind. This is what I got to say. Thanks. Sorry for all those technical glitches. Somehow we could manage it. Thanks for the invitation. Thanks to my alma mater, Mysore University, my two senior colleagues, Professor Ramesh and Professor Benjamin. Thank you so much.
Thank you,
Thank
sir.
you, sir.
Now
Now
let's
let's
officially
officially
close our
close our
event with
event
the
with the
vote of
vote of
thanks
thanks
by
by
Professor Dr.
Dr.
Ramesh,
Ramesh,
organizing
Organizing
secretary
Secretary
of
of
this
this
event,
event,
and
and
senior
Senior
professor
Professor
of
of
law
Law
at
at the
Department
Department
of
of
Studies
Studies
in
in
Law,
Law,
University of
University of
Mysore.
Mysore.
Sir,
Sir,
over to
over
you.
to you.
A very warm good evening to each and everybody. There is a statement known is a drop or known is ocean. Similar to this statement, the growth of law across the various countries or across the globe is moving very, very fast, especially as stated by our Honorable Chairman, Dean Faculty of Law, Professor Suresh Benjamin, that after 1991, when India embraced the globalization, privatization, and liberalization by the efforts made by then Prime Minister Manmohan Singh, we are witnessing various challenges till today. In these connections, the University of Mysore, with the efforts made by our colleagues, have made just a simple attempt to know and disseminate the knowledge relating to the very important topic, that is international webinar on the intricate interplay of investment law and intellectual property in India. I'm just observing, and I'm also teaching the intellectual property rights law and the WTO also too, and interlinked with that of the investment law. There is a lot of development and a growth in all these three areas. And of course, India is in the very important stage, which is encouraging all the people in its country to take the research work for the overall development of the country. In these connections, when we have decided to have an international webinar on this particular unique topic, I can put it, unique topic, we have some very familiar and a good professors who are expertise in many important aspects. In that regarding, when we just look at the various professors like Prabhas Ranjan, Dr. Srinivasulu, Antonio George, and Kenneth Mutomo, and Nicholas Day, they all actually made their expertise through their presentations in a very unique way. Now I'm coming to the back end of this international webinar. On behalf of the University of Mysore, Department of Studies in Law, and on behalf of myself, on behalf of the Chairman, Department of Studies in Law, and our students, I extend my heartfelt thanks to Dr. Lokanath N K for having accepted our invitation to act as a chief guest and deliver the inaugural address, and he has delivered it very effectively, and he has also guided to move in the right directions, and he also promised us the University of Mysore will always be there with all these kinds of academic endeavors. On behalf of all of you, I extend a very heartfelt thanks to our Honorable Professor Lokanath N K. Thank you, sir. It was very thought-provoking presentation made by Prof. especially by referring to the concept of compulsory licensing under Section 84 of the Indian Patent Act. I was so familiar with, sir, I am so familiar with the one case, that is NATCO versus Bayer case. And that how the Honorable Supreme Court interfered in order to protect the interest of the public. Sir, your lecture was so good to uh, listen to you, and it's a thought-provoking. Definitely, we have learned a lot from you, sir. I am on behalf of each and everybody, on behalf of the University of Mysore, convey my heartfelt thanks to Professor Dr. Prabhas Ranjan, sir. Thank you very much, sir, for having be with us. And then we had a very important talk by Nicholas de Satelier, professor of Brussels and Belgium, who has enlightened us on the UE investment. That is very, very important, because when I just made it very clear, I was just reading an article. Till today, that means as in 2023, in India, only 17% of household persons are involved in investment in stock market. You can just imagine that. How about the case of remaining 83%? This kind of an very influential talk will definitely increase us to think about the investment and the investment law. Sir, you have enlightened us regarding the investment, especially the state dispute settlement also. That was a very important consignment that has been given to all of us on behalf of each and everybody and the University of Mysore and Department of Studies in Law. I convey my heartfelt thanks to you, sir. And then comes to the Professor Dr. Srinivasulu, MS, pride alumni of our department. And this is what actually I can say, that he's a very good friend of mine and a pioneer in all aspects, in fact. And when we just look at his CV, and we are so happy, that you have grown up to that an unimaginable extent. And whatever the topic that may be given, that comes so fluently without any stoppage. That's what actually you made us to mesmerize the entire program. That's what actually it's telling. Because why I'm just telling all these things, one of my students is also pursuing PhD on this particular topic. Yes. That's why I was so curious to know about your talk. And you have enlightened us. Sir, there is a lot of things to learn from every angle, from everybody, irrespective of their age and everything. So, in these connections, your talk and the presentations, especially regarding the privatizations and everything, and which was interlinked with that of the physics, was thought-provoking. I convey my heartfelt thanks to Professor and Dr. Srinivasulu for having shared his thought in this international webinar. Thank you, sir.
Thank you, sir.
Thank you, sir. One more professor, Dr. Antonio George Pereira Jr., a university professor from Brazil. He has presented his views in a very effective way on the topic protecting the IPR investment within the BRICS framework, challenges and opportunities. And I think this is very, very important also because how the international organization are making efforts to channelize these kinds of IPR and investment laws so that that will be a thought-provoking talk wherein we have learnt everything and everything from your end, sir. On behalf of my University of Mysore Department of Studies in Law and on behalf of our chairman, Dean, I convey my heartfelt thanks to you, sir. And one more professor who has presented his views on the dispute resolution environment as a corollary, IPR as investment. That is Kenneth Wine Mutomo. That is very nice, important because last week we have discussed some important point about the sustainable development goal also from the perspective of the environment also. Sir, your talk and the presentation was so informative to all of us so that we can carry it on to our students when we are delivering our lecture, regular lecture in the regular classes. I, on behalf of all of you, convey my heartfelt thanks to Kenneth Motuma for having presented his views on a very important topic. Thank you, sir. I also extend or convey my thanks to all the university officials who have either directly and indirectly helped us in successfully conducting this international webinar. I also convey my heartfelt thanks to so-called our chairman, the Dean, Faculty of Law, and in fact is a man who is behind all these curricular activities. That's how, in my opinion, a chairman ought to be. That's a quality of a leadership, in fact, wherein he can bring each and everybody to very unique functions like this. Because without a leader, leaders are there, but only few people are there with a leadership quality. That's what actually I just want. A leader with a leadership quality that I can come across only with persons like Suresh Benjamin, and he helped us in conducting this international webinar so successfully along with us, and he has also guided us, sir, on behalf of the Department of Studies in Law and all of us and University of Mysore. I convey my heartfelt thanks to you, sir. And my student Kudrat is also there. Should not actually convey thanks to him because he's a very junior to all of us. But anyway, no, according to our Indian tradition, it should not be. But anyway, but he used to work hard, and the entire credit should goes to him. Entire credit should goes to him because conducting the seminar is not so easy task. Convincing the resource persons, convincing the participant to take active participation in this international webinar, it's not an easy task. So nevertheless, he made it and he's doing it. And in fact, I assure him that in all of his academic endeavor, we and Benjamin will always be with him. Okay, I convey my heartfelt thanks to you. And I also convey my blessings to Sarah Benjamin. This is a surprisingly, she has made a very good contribution when you are actually making some note about all the resource persons. In fact, that mesmerized me like anything. God bless you, Amma. I wish you all the best in the days to come. And I also, Milan, Milan. I also convey my heartfelt thanks to Milan and all those who have directly and indirectly helped us in this regard for successfully conducting this particular international webinar on a very unique topic see you forward in the same endeavor in the days to come. Thank you, one and all. Please take care of your health. Thank you, one and all.
Thank you, sir.
Thank you, sir. Thank you so much.
Thank you.
Thank you.
We are
We are
also
also
grateful
grateful
to you
that,
that
sir, you have also guided us
for
for this
webinar.